So there you have it. Pack your bags. We are all headed to Judge Gilday's court on July 1st, 2026 at 3 p.m. Expect to see every single attorney, no matter how far they live, that ever signed their name to represent any of the parties, especially Karen Reed and her 79 attorneys. Okay, we got some major breaking news in the Karen Reed case involving the estate of John O'Keefe. Recall, this is the lawsuit that was filed on behalf of John's estate against Karen for wrongful death. And our favorite no-nonsense Judge Gilday issued a scathing order today, setting forth multiple things that the parties must do, including every single attorney appearing for an in-person hearing on Wednesday, July 1st. Let's get into this. There's major speculation that the order the judge is referring to is his impoundment order, meaning he doesn't want any of the information regarding this order released, and apparently it was, and apparently it deals with Michael Proctor's medical records. Let's go back to the hearing for which Michael Proctor's attorney set forth various concerns he had in front of Judge Gilday.
Good morning, Attorney Hamill. Apologize for the delay. As is usual, our technology in the courts is not well equipped to do things such as this on the fly.
In the bottom left corner is Michael Proctor's attorney. In the top right corner, of course, is Karen Reed's African-American attorney, Damon Seligson.
Does Ms. Reed's attorneys want to be heard further on the motion to impound beyond what you wrote in opposition?
Recall that before the judge was a motion to impound. That's another fancy term for keep a secret, meaning that whatever information that was set forth in Proctor's motion, his attorneys want to keep private, meaning we can't see it.
Well, beyond what we've written in the opposition, no. With respect to the motion to impound only, we believe that certain aspects of it are appropriate for impoundment, but
we believe that the motion we've submitted in the materials that are provisionally impounded that we submitted to the court per the court's order readily support impoundment of those materials under Rule 2. We feel that we've put the majority of what we need to put into our papers, but for the court's information, within hours of our firm sending to the clerk and to counsel the motion and the two affidavits, which are provisionally impounded per the court's order, within hours, my client and his family members received harassing phone calls pertaining to information contained in those affidavits.
Wow, we received harassing phone calls. Little does this attorney know what we're about to find out just a month later with regard to what was on his client's cell phone. And trust me, a little harassing phone call is nothing to what was on there.
I think it's safe to assume that the clerk's office did not disseminate that information on a Sunday afternoon, Your Honor. I obviously can't connect any dots, and I don't intend to do so here, but that is why we are seeking impoundment. This is obviously a very public case. I don't need to tell anyone that. But I don't believe that our client's medical personal information needs to be all over the internet when we're just seeking a new deposition date.
Inference from Mr. Hamill about how whatever he filed on Sunday ends up on the internet. There is a categorically deny and reject.
Attorney Seligson, he didn't point any fingers. He could have meant me. I don't know. So let's move on. All right.
Okay. Thank you, Judge.
All right.
And there you have it. Based upon what we saw there, most likely the judge's orders relate to Michael Proctor's medical records that was somehow allegedly released. Now let's take a look at the order the judge issued following that hearing. Ever the conservationist, Judge Gilday simply writes his orders on the side of the papers for which the attorney submitted. Let's read it. It's dated June 28, 2026, after hearing and having balanced the rights of the parties and the non-party deponent based on the particular facts of this case and taking into account all relevant factors, including but not limited to the nature of the parties and the controversy, the type of information and the privacy interests involved, the extent of the community interest, and the reason for the request, I find good cause to impound and so order the impoundment of, for a period of 30 years, the affidavit attached to this motion. I recognize the fear of unjustified adverse publicity is not sufficient to constitute good cause. However, a legitimate expectation of privacy ordinarily is sufficient to constitute good cause. Here, the judge is basically saying that for the next 30 years, we will not have access to whatever is in the affidavit of Michael Proctor's attorney, but that's no big deal. We're willing to wait 30 years. Okay, and due to this apparent leak, Judge Gilday just issued this particular order. Let's read it. I have been advised of information that allows for a reasonable inference of a violation of an order of impoundment issued by me. It is hereby ordered that 1. Each plaintiff and defendant and each counsel with a notice of appearance in this matter as of June 8, 2026 shall file with the clerk on or before 4:30 p.m. on Tuesday, June 30th, that's tomorrow, a certification under the pains and penalties of perjury as to all facts known to them as to any dissemination to anyone other than parties and counsel in this matter of any of the contents of the material impounded by order issued on June 8th. Wow, what does that mean? Not only does every single one of Karen Reed's 74 attorneys must appear, they also must set forth in writing their knowledge under the pains and penalties of perjury of any disclosure of the impounded information which we believe is Michael Proctor's medical records. Number 2, an in-person hearing is scheduled for Wednesday, July 1st, 2026 at 3 p.m. All counsel with a notice of appearance shall attend. That means every single attorney must haul their ass in front of Judge Gilday, laying all excuses aside and answer to what he is requesting. And that means that old Alan Jackson and any other attorneys that ever signed their name to represent Karen Reed in this particular lawsuit must fly, drive, bike, or swim to Judge Gilday's courthouse on Wednesday. Number 3, all further attempts to take discovery from the party whose information was subject of the order of impoundment is precluded pending further orders of the court. And that's some major breaking news. That means that any discovery, including further depositions or document requests or information requests, must cease, assuming that this is Michael Proctor, until the judge issues a subsequent order. While that may seem drastic, most of the time, none of the parties ever figure out who actually leaked the documents and or information. So Michael Proctor does get a last-minute reprieve from old Judge Gilday to not have to appear for his next deposition date. However, most likely, eventually, Judge Gilday will order that Michael Proctor must finish his discovery, meaning he must sit for a deposition and produce any outstanding documents. So there you have it. Pack your bags. We are all headed till Judge Gilday's court on July 1st, 2026 at 3 p.m. Expect to see every single attorney, no matter how far they live, that ever signed their name to represent any of the parties, especially Karen Reed and her 79 attorneys. But no matter what Judge Gilday orders, we will never, ever stop producing these videos until the real killer,
Brian Higgins,
is brought to justice.
the face-to-face version of trying to suss out and vet, like, what is this all about?
This crime was very simple to solve because it took place within a very small area over a very short period of time with a very limited amount of suspects. One or more of these 10 people has to be the killer of John O'Keefe. That's how easy this is. Once you remove the kids and the McCabe's, you're down to just 3 suspects: Brian Albert, Higgy Bear, and Chloe. Since Chloe's a good dog, she didn't do it.
I didn't do it. I'm a good dog. I didn't do it.
So that leaves just 2 suspects, Brian Albert and Higgy Bear. But of the 2 Brians, only one had the means, motive, and opportunity to kill John O'Keefe. And that's our old cuddly but violent Higgy Bear. Once we had all the facts and didn't jump to conclusions, do you see how easy it was to solve this crime?
I love you, gay Jeff.